If you don't plan, you're stupid.
Welcome back to If You Don't Plan, You're Stupid with Florida estate planning attorney Andy Rosenberg. Now, Andy helps families across South Florida protect their assets, avoid probate, and make sure their plans actually work when it matters most. I'm Evan Mack, and today we're talking about a DIY online estate planning forms. They promise a quick, affordable fix, but in Florida, quick and cheap can turn into invalid and expensive. Let's talk about why. Andy, sir, welcome back.
Hey there, Evan. How you doing, buddy?
I'm well. This is going to be the truth about DIY estate planning forms in Florida. Let's get down to the nitty gritty. Can you explain to the people why using this online will and trust and why do people do these templates? Why do people use these templates?
Well, why do you think they do it? They're cheap.
Because it's cheap.
Man, listen, I get it. I totally get it. I mean,
Yeah.
listen, I'm always looking for a bargain. I'm trying to save money where I can. My wife doesn't. That's a whole nother story there. But
that's a different podcast right there.
But no, I mean, listen, most people try to do it yourself for kind of templates or whatever, because number one, it's cheap, it's low cost, which I understand. Number two, it's convenient and it's fast, because literally you could be at 2:00 in the morning and you couldn't sleep, and you went and you get online and you start filling out the documentation, etc., and you pay $100 or $50 or 200, whatever it is, and you're doing it at your own convenience and your own speed. And number three, it's usually interactive because they just lead you along questions, and you answer the questions and move on. And then there is somewhat some flexibility with it, not a lot. And then it's peace of mind in the fact that you at least did something.
Right.
You at least did something. So there's a lot of factors as to why people want to do it yourself, templates for estate planning. But you get what you pay for, if you know what I mean. I mean, I always use these two sayings, but don't be penny wise and pound foolish, number one. And you can lead a horse to water, but you can't make them drink, right? Those are the two things I say a lot. And that is so true dealing with do-it-yourselfers and estate planning. And listen, do-it-yourselfers think they know everything, and let them do it yourself. I mean, there's a reason why these companies are in business, because people are doing it themselves.
Right.
The problem becomes when they pass away, and it's for lack of a better term, it's a shit show.
Yeah.
When it comes to their documents, because they're not done properly, and then it's the Pandora's box. It just opens up, and it's a freaking disaster.
Absolutely.
So yes, I get that people want to do this stuff, but I always tell people, listen, when I sell my house or buy a house, I don't do it myself. I hire a real estate attorney.
Well said.
Right? If God forbid I get a speeding ticket, which my daughter gets too many, Allie, if you're listening, no more speeding tickets, please. But I have her hire an attorney that deals with the ticket clinic. Get rid of this thing. When it comes to estate planning, don't mess around. Hire an estate and elder law attorney, because how often are you going to actually do this? And you want to make sure it's done right the first time.
Yeah, we got to tell Allie to slow down. Slow down, Allie.
Absolutely. And she used to have, I'll tell you what, she used to have a red car, and she got nailed all the time with a red car. So I'm telling people, she's got a white car, and she, knock on wood, I'm knocking on my head, she hasn't gotten a ticket in years, and it's because it's a white car.
I believe it. That red car that's a real thing. I've heard that
a real thing.
Many cops, man. They're like, we always look for those red cars.
Absolutely. So one of the things you learn out of the podcast, get rid of your red car.
That's free advice, man. Listen, Florida has some of the strictest rules about signing and witnessing estate documents. What kind of mistakes do you see when people do that with these DIY forms?
Yeah, and that's probably the biggest problem with the DIYs or DIY? DIY. Whatever. Do it yourself. I can't ever remember.
I'm just gonna say you do it yourself from now on. Go
ahead. Florida's really particular about how you get things executed. And I mean, in Florida, there's a statute that just talks about for wills. How do you properly execute a will? I mean, it has to be done with 2 witnesses and a notary. Has to be done in front of each other. They have to see each other sign the documents.
Woo.
You have to have a self-proof affidavit. Um, the
Wow.
the personal representative or executor of the will, the person in charge of the will, has to be
Incredible.
18 years of age or older.
Incredible.
Um, they- yeah, and they have to be from the state of Florida unless they're family members from, they can be anywhere. So there's a lot of formalities that are involved where it can easily get screwed up, and that's the problem. And it's just it's a problem. And we haven't talked about it, but we can talk about it for a minute here, Kev. Or Kev, sorry, I did it again.
You good?
I'm so
You
used
good?
to Kevin. It's Evan. I
Yep.
apologize, Evan. Homestead property. Okay. Florida has this whole separate, I'm not sure all states have this, but Florida has this separate thing for homestead. So it's dealing with your real estate, and there's special laws and rules regarding homestead and how it can be transferred. And so if you do the wrong transfer in your will, your do-it-yourself will, saying I want the house to go to my spouse, or to this person or that person, it may not legally be allowable because you're not following the proper laws for the state of Florida in that situation. Because if you have a spouse and minor children in Florida, the homestead has to go to them. So if you screw that up in the will, it's going to cause all sorts of problems. If there's ambiguous language in a lot of these do-it-yourself documents, the language isn't proper.
Yep.
And it's ambiguous. And then that's a disaster because now we got to get the courts involved big time. And then we got court hearings. So we got those problems. You got other issues that people forget about that aren't even involved with the do-it-yourselfers as far as the estate plan, but it is part of the estate plan. What about your beneficiary designations? How have you done that as well? Besides doing your do-it-yourself wills, you got to also remember about naming a proper residuary beneficiary in the will, or if you have like IRAs and 401ks and life insurance and annuities and all these, they have beneficiary forms. Have you done the beneficiary form correctly or not? Have you named the contingent beneficiary or not? Has that beneficiary that you named predeceased you and you didn't name anybody as an alternate? These are all issues that are going to pop up if you don't do proper estate planning. That's why it's really important. Like I said at the beginning of the podcast, Evan, if you're going to do estate planning, more likely than not, you should hire an estate planning and elder law attorney to do it because it's something that can get easily screwed up.
So they always talk, these websites promising you the simple one size fits all plan. Why is it important that an estate plan be customized for Florida law and in a person's like unique situation, their individual situation?
Yeah, well, so the do-it-yourself forms tend to be generic, obviously, in nature. And and I tell everybody this, I do tons of workshops, Evan, and I tell everybody, I talk general terms about all this stuff in the workshops, and I turn to the audience and I tell everybody, listen, I'm talking about stuff in general terms. I need you to sit down with me to talk about your situation because everyone is unique. Not every estate plan is exactly the same. And that's what I'm trying to tell you about the do-it-yourselfers is it may not deal with what happens if you have minor children.
Right.
We got to deal with guardianship issues. And what about how do you set it up so that if you pass away and the kids are under 18 and you want the kids to get the money, now we're going to have a guardianship for the kids until they're 18 years of age. Maybe that's not what you wanted. Maybe you wanted the kids to get the money at age 21, a portion, age 25, a portion, and the rest at 30 years of age. So those are unique situations where you have minors. What happens if you have children that have special needs? God forbid you have a kid that has special circumstances. How do you plan for that properly? You want to make sure that you don't screw it up. Maybe they're on benefits with the state and the federal government. You want to make sure that continues. If you do it, if you distribute things the wrong way in the your do-it-yourself documents, you could screw up their entire thing and they could lose their government benefits. So there's all sorts of issues and concerns. So what happens if we have kids where we're concerned about maybe one of the kids is you're not happy with their spouse
Mhm.
and you're concerned they're going to go through a divorce. Well, what do we do there? How
Mm,
do we set up an estate plan to deal with those issues? What happens if we have
mm,
kids that have creditor issues? How do we make sure that the kid gets the money without having the creditors attached to their
mm.
benefit? So there's so many issues dealing with the estate plan that people don't even think about. The problem is, Evan, is that people, the do-it-yourselfers, a lot of them think they know everything already,
Yeah.
and so they're not opening up their brains to the ideas of, oh, I got a kid that's got some financial issues. They're not good with money. I got a kid that's got special needs. I got a kid that's married and I don't like the spouse and I'm concerned there might be a divorce. And then if you just leave everything to these people, it's going to cause problems. So you have to open up your eyes to the bigger picture and open up your wallet, guys, and spend the money where it's necessary to do the right thing.
Do you have an example where a family uses do-it-yourself approach and it kinda backfired? Do you have some kinda
I got
example? I'm sure
I
you
got a
do.
perfect one recently. I have a perfect recent one, and it made me sick to my stomach. So I had I had a father pass away. So the kid came in, the adult child came in to meet with me, and said, "Listen, um, my dad had assets, and it was about $600,000 to $800,000 of total, including the house and then stocks and bonds and everything. And he didn't have an estate plan except for he had a will. Okay, he didn't do a trust or anything, which is fine. He had a will, and he did it himself. He did the will himself. It's called a holographic will. That's what we call it in Florida when it's a do-it-yourselfer. And it
Mhm.
was typed. It was typed, and then it was signed. And the client, the son, came to me and said, "Here's the will."
Mm,
And I looked at him. I said, "Well," I said, "who did the will?" And he says,
mhm.
"My dad." I said, "Your dad did it on his own?" He said, "Yeah, he did a form online." I said, "Okay, let me see it." So he showed it to me, and again, it showed him. It showed the language, which was horrible, and it showed that Dad signed it at the end, and there are
Right.
no witnesses, and no notary. And I turned to him. I said, "Listen, this in the state of Florida doesn't exist. It's called a holographic will. Doesn't exist, and so it's as if you never had anything." So now I said the state of Florida is going to control this situation. It's called dying intestate, dying without a will, because that's what we have now at that point. And then I said, and then here's the kicker though, Evan. I said, "How many kids are involved? Is it just you?" And because in his dad's will, he gave everything to this one son.
Oh, wow.
Yeah. So it turns out that he has two kids from a prior relationship. And because of that, and because he did the will himself and it's invalid, it's going to go a third, a third, a third to all three kids. Exactly the opposite of what dad wanted.
Wow.
And that just recently happened.
That's
So
wild.
it's a double whammy. Here's the double whammy. The will's not going to work because it was a holographic will and wasn't done properly. Did it yourself online and was done wrong. So that's number one whammy. Number two whammy is now we're going to go through probate court because it's the way he set it up. If he met with an attorney, he should have spent a couple $1,000 and we would have avoided the entire court process. That's the second whammy. The third whammy is that because it wasn't done properly and there are other kids involved, the other kids are now entitled to an equal share with that son. So now he's
Mm,
losing. He's not getting 100%. He's going to get a third, a third, a third. So there's a real life example, and I
Yeah.
see it every day, Kevin.
Yeah, that one's pretty that's pretty extreme.
Yep.
But it makes so much sense though. It's based on the law you say in Florida and all the things you have to do. But,
Yep.
some people try to handle their estate plan on their own. The first they try to figure out, and then have a person like you fix it later. Can you talk about why that approach ends up causing more problems later on, even though they come to you, but there's a huge mess they have to fix?
Well, first off, I commend anybody for obviously doing anything, although I'm not a fan of the do-it-yourself documents or templates. But number one, I always tell people when they come in and they've done it themselves, or it was done by an attorney that's not an elder law attorney, done by just a family law attorney or someone, and they think they know what they're doing, they just plug in this stuff and it's done. So number one, always I compliment them, but I also have to veer them and tell them, listen, here's the concerns,
Mm-hmm.
and then I tell them we got concerns because of A, B, C, and D. It's not
Mm-hmm.
addressed. These are the issues. We need to address these issues. And if the person is still alive, hopefully, and competent, we can deal with those issues. Okay? If they're passed away and then the family comes to me with that issue, we're done. So I tell everybody, listen, nothing's too late until you pass away. Once you pass away, whatever you did, there's nothing we could do. So whatever you've done in advance prior, don't worry about it. Bring it to a competent attorney. Let he or she review it and say, yeah, it looks great, or no, it's not good, and here's why, and these are the issues we need to address, and these are your options. So that's what you need to deal with. Now, I want to address something else. Did that answer the question,
Absolutely.
Evan?
Yeah.
I want to deal with something else real quick, because I know that what other people, we're talking about do-it-yourselfers with their estate plan documents.
Right.
A lot of times people do do-it-yourselfers with the real estate, and they'll put their kids on the deed or whatever and think they're doing the right thing. And I'm just letting everyone know that that's a disaster as well. Okay? So titling assets, maybe they put their kids on the bank account or their kids on their investment accounts with them, to make sure everything goes smoothly. When I pass away, it just goes to my kids. Yes, it goes to your kids. Yes, it's doing all of that. But you've really screwed things up by doing that. How have you screwed things up? Because there are two things. One is when you put your kids on bank accounts or on the deed to the house or whatever, number one, that's considered a gift. So there should be a gift tax return filed with your CPA. That's number one, which no one ever does, but that's supposed to happen. Number two, you really screwed it up for the kids when they inherit it. Because I'm going to get a little complicated here for a second. We have something called stepped up death benefit. So what happens is, I'll give you an example, Evan. We'll talk about my house. My house I bought for $350,000 many years ago. It's now worth $1.5 to $2 million, somewhere in there.
Amazing.
Yeah, I would never pay for that, but that's besides the point. So let's just say $300,000 and $2 million. Okay, I bought it for $300. It's now $2 million. There's a huge amount of growth there, right? There's $1.7 million of growth. When I pass away, my kids will get the value at date of death value, the $2 million. They can literally sell the house the next day for $2 million and not have any taxes. It's called stepped up death benefit. When you put the kids on the deed with me, if I say I'm adding my kids on the house while I'm alive, then 50% in that situation, 50% of the house will lose that stepped up death benefit.
Okay.
So that means that there's going to be a huge amount of capital gains tax if the kids want to sell it the next day when I die. So you're causing all sorts of problems tax-wise, not necessarily right away, but when mom or dad passes away, it's going to be a big tax problem for you that you didn't even know about. And that's why, because you did it yourself and you didn't speak to a competent estate planning or elder law attorney or CPA in that matter. So there's a lot of problems with do-it-yourselfers. I understand there are people out there that are going to do it and go do it, but just be aware of the consequences.
Absolutely. And speaking of those people, anybody listening who've been putting this off because they think estate planning has to be complicated or expensive, what would you tell those people listening right now?
I would tell people it's going to be a lot more expensive and complicated if you don't do anything, or if you do it yourself. I see my dog walking behind me.
I see your doggy too.
Hey, Gary just got in on a podcast. But yeah, so if you do it yourself, it's probably more likely not going to get a lot more complicated and expensive than it needs to be. Yes, you're going to have to pay an attorney maybe a couple $1,000s to get it done properly. But hey, you know it's done, and you got that quote peace of mind at that point. But also, everyone needs to remember this, and I wrote this in my book that just came out. Remember this: even when you do an estate plan with an estate attorney, you still need to review it every couple years because life is dynamic. It's not stagnant. Things change. Life changes. People come in and out of your life. People die. People are born. That changes your estate plan. Let's make sure it's up to date every couple years.
Well said. Thank you, sir.
You got it.
All righty, and that's it for today's episode. And if you don't plan, you're stupid. Online forms might save you some money today, but they can cost your family thousands tomorrow. If you've made your own will or trust and aren't sure if it's valid in the state of Florida, visit rosenberglawfirm.net to get it reviewed before it's too late. Don't forget to review, subscribe, and share the show with someone that might find this information helpful as well. Thank you so much, and we'll see you next time.
Thanks, Kevin, and go Hoosiers. They're number 2 in the
wow.
country.
Wow, I didn't see that coming.
Go Hoosiers. Take care, everybody.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.